Well, a new paper released today and written by the chairman of the think tank, the New Zealand Initiative, Roger Partridge, argues that the New Zealand Supreme Court is overreaching its role and that judicial supremacy must be reined in. Now, I did warn you about this judicial activism after the Family First case in the Supreme Court 2 years ago. Let me remind you of what that was all about. So according to the New Zealand Herald report, the report says the court is straying into Parliament's domain and is granting itself the power to rewrite legislation it does not like. That's the Supreme Court. The report says Parliament needs to reassert its sovereignty and to stop the current drift towards judicial supremacy. And one of the measures proposed is imposing a term of 5 to 7 years on the Supreme Court before then returning to the Court of Appeal and promoting other Court of Appeal judges to the vacated Supreme Court position. So you're not on it for life, but you do get rotated around so that you don't have supreme power. Now, this is the paper, and the New Zealand Herald report says the paper is highly critical of how the Supreme Court has developed in its first 20 years. The court had embraced a very loose or liberal approach to interpreting laws passed by Parliament. The report echoes concerns this year by Senior Barrister Jack Hodder KC in a conference paper on the Supreme Court in which he expressed a troubling sense of unease about a remarkable level of mission creep in the court's role. Quote, "In our democracy, the courts have no mandate to become agents of societal change," Hodder wrote. In making the case that change was required, the paper cites several controversial decisions, including the Make It 16 case, in which the court found the voting age of 18 to be discriminatory. I mean, why not 11-year-olds, 5-year-olds to vote? And Smith versus Fonterra, allowing a case against 7 large greenhouse gas emitters to proceed. The paper also uses 2 other judgments of the Supreme Court to illustrate overreach. One is the Ellis case, the Peter Ellis case, quashing his convictions based on tikanga. And the other case is a 3 strikes case where the Supreme Court interpreted the law passed by Parliament in a way that Parliament never intended. But interestingly, the Family First case is mentioned in the report, and it says this: in Attorney General versus Family First New Zealand, the majority defined the common law method as incremental development of the law to adjust to societal changes. The majority's decision echoes the court's earlier decision in another case where the justice said, "We are changing the law because of a change in perceptions over time of what public and legal policy require." But as Hodder questions of the claim changes, whose perception? When and why did any such change occur? What evidence and what accountability? And you'll see there it says, this approach to developing the common law raises serious concerns about the separations of powers when judges reshape the law based on their perception. It's a key line. Their perception of changing social values. They assume a role constitutionally reserved for Parliament. So let me remind you of the Family First case in the Supreme Court. And this is what the Supreme Court said. Well, hang on, let me go back a step. Firstly, the Supreme Court basically agreed with the government to deregister Family First as a charity in 2022. Now, this was after the Court of Appeal in 2020 had found in our favour, retaining our charitable status. And there's been 4 court cases over the last decade attempting to resolve the issue. And the reasoning behind the Supreme Court overruling the decision of the Court of Appeal and the justification for deregistering Family First, well, it should concern anyone who values free speech and traditional and conservative views around family and marriage. And it was also, I think it's a warning for the church as well. So the Supreme Court activism started with the Family First case. Now, before I show you what the Supreme Court said, let's just remind you of the decision of the Court of Appeal, the next court down, the 3 justices, only 12 months before. And they said this: some key statements made by the Court of Appeal in coming to their judgment was this: An examination of Family First materials set out in the context of advancement of education and research shows Family First's clear purpose of stimulating a public debate and participating in public discourse on important social issues relevant to families. Public discussion and debate about such important issues, Public discussion and debate about such important issues is desirable to encourage the development of related policies and laws. The end promoted by Family First is the support of marriage and family or core family values. This is an abstraction not dissimilar to the examples given in Greenpeace or world peace or nuclear disarmament. As already analysed, Family First seeks to educate and conduct research. And then it would be curious if promotion of what the board called the traditional family would cease to be of public benefit because there is a growing acceptance of other forms of stable family life, including within whānau and hapu relationships. And to be fair, Family First recognise the contribution non-traditional forms of family life can make. And then finally, we consider Family First's engagement in the deliberations of the community on issues such as abortion, assisted death, anti-smacking laws, prostitution reform and censorship is properly characterised as part of its broader purpose of supporting marriage and family as being foundational to a strong and enduring society. Any attempt to label such engagement generally as cause advocacy of a political nature is not helpful. Well, when the Court of Appeal ruled in our favour, the government appealed to the Supreme Court. And you can read the full long decision of the Supreme Court. I'll put the link in the explainer. But the most significant statement is where the court rejects our views of marriage. And they say this. So this is the Supreme Court talking. We do not agree with the Court of Appeal majority that Family First's advocacy of the role and importance of this particular version of the family and of marriage between a man and a woman is self-evidently beneficial in a charitable sense. Oh dear. The ideology immediately comes through. They disagree with our view, a view that most of society held until about 5 minutes ago. What other views will become uncharitable sometime soon? The definition of a woman? Now, in the Supreme Court's media release, which summarised the judgment, and the media quoted primarily from the media statement, it's uncertain whether they read the whole judgment, the media statement from the Supreme Court said this: Family First believes that the traditional family, a permanent union of man and woman, is the best model for delivering the societal benefits associated with stable family life. It puts these principles into operation by, among other things, commissioning research reports, proposing legislative reforms aligning with its views, hosting conferences, and collating information on its website. Family First's purpose, exhibited by its trust deed and activities, crossed the line between education and advocacy. Its research reports lack the balance that is required to further an educative purpose. By publishing research reports, hosting conferences, posting information on its website, and suggesting law reforms, it sought to advocate for the adoption of its views concerning the traditional family. Now, there are two problems with these paragraphs. All charities both educate and advocate. The Helen Clark Foundation, Drug Foundation, Child Poverty Action Group, Greenpeace, Amnesty International, Save Animals from Exploitation, National Council of Women, we all advocate a viewpoint. Both the Helen Clark Foundation and the Drug Foundation tried to advocate for the legalisation of cannabis in the referendum. Fortunately, they failed. And we're sure you know what Greenpeace's opinion is on certain issues. But secondly, the statement ignores the huge amount of research Family First has done on issues which have nothing to do with family structure. For example, the health harms of pornography, screen time, childcare, gender identity, fertility rates, family dinners, censorship, prostitution, child abuse, and many other issues. Now the court continues, the Supreme Court, supporting the family and marriage is not a purpose beneficial to the community and charitable. Wow. By analogy to previously recognised purposes, Family First purpose is to advocate. Although Greenpeace opened the door for advocacy-based purposes in limited situations, Family First did not satisfy the criteria. It advocated a particular version of the family, being the traditional man-woman marriage. Its purposes are discriminatory. It advocates for measures to prefer the traditional family to the disadvantage of others. No, we simply present evidence that argues that family structure matters and that marriage matters. In our view, the research is clear and overwhelming. If they disagree, put up the research that proves us wrong. Debate the issue. But they seem to want to shut it down. But what are the limited situations where advocacy is cool? When can you do advocacy, according to the Supreme Court justices? Well, here's the telling bit. Family First's engagement with issues such as abortion, assisted dying, prostitution and censorship were not subsets of its wider purpose of supporting marriage and family. They're freestanding political objects about which there are differing views in society. That's okay. For such issues, it is not possible for the court to determine whether the views promoted are publicly beneficial or otherwise charitable. This differs from advocacy for ends like human rights and protection of the environment, which Greenpeace held were themselves charitable ends. Family First's advocacy on the above issues was not ancillary to its expressed purpose of supporting marriage and family. This is the key point to understand. The court is saying that the religions of human rights, including sexuality, gender, identity politics, and environmentalism are acceptable things to advocate for. But to present and use decades of research proving that family formation and structure matters is unacceptable, to present that type of material is unacceptable and apparently discriminatory. Now, finally, one of the justices, Justice Williams, was very critical of us, of Family First, although it's important to note that his view was not shared by the other 4 justices. In fact, Justice Williams never challenged our lawyer during the court case on this issue. He just sort of sat on his own radical ideology and then spewed out a statement. No natural justice for us to respond or challenge. But he said this, let me just get it up. To help guide future decision making, Williams J. suggested that selflessness can operate as a touchstone. Substantially self-regarding purposes should not, in principle, be charitable. Using that approach, Williams J. agreed Family First did not qualify as an educational charity. One-sided promotion of personally held views detracts from the cohesiveness of our pluralistic society and disempowers the receiver by failing fairly to inform them of alternative viewpoints on the subject. Family First promotion is self-referential. It is not about community. Well, with due respect, this is just confused thinking by the justice. There is no selfishness in doing research and advocacy to strengthen families, encourage marriage, respect the sanctity of life, and protect freedom. As already stated, every charity is promoting their cause, their view. On this measure, every charity should be deregistered if they have a view and promote that view. And pluralistic society, well, that's a buzzword with no specific meaning. But what it does do is simply reinforce that there will be differing views that deserve debate. He continues, advocating for controversial ideas or causes may be charitable where the group addresses the issue in a balanced way. Honesty and respect in debates is not self-referential, but Family First advocacy is not fair, balanced or respectful, so its advocacy is not charitable. Well, we completely disagree. In fact, we challenge Justice Williams to give evidence of his claims. He obviously doesn't agree with our opinions, but his character assassination is highly subjective and is itself not fair, balanced or respectful. We know and trust that you as our supporters would call us out immediately if we were guilty of any of those accusations. Our research reports have never been proved to be factually incorrect. Opponents simply disagree with them, which they're entitled to do. We would argue that most of the reports out of the Helen Clark Foundation and the Drug Foundation haven't been fair or balanced either. Aren't there other charities who do advocacy? Yep. As I said, Helen Clark Foundation, New Zealand Drug Foundation, Child Poverty Action Group, Amnesty International, SAFE, National Council of Women, Rainbow Wellington, Royal Forest and Bird Protection Society. And we don't believe these groups should be deregistered. We simply ask for a level playing field and equal treatment, which the Supreme Court is not giving. Now, can we appeal the decision relating to Family First? Well, no, we've reached the end of the appeal process. We've been to the highest court in the land. The only way the confusion and inconsistency around the determination of charitable status and the role of advocacy can be fixed is by Parliament. Now, interestingly enough, when Greenpeace was appealing their charitable status, well, the Labour and Greens were all over it. Labour had a policy to make sure that you wouldn't lose your charitable status if you were engaging in advocacy. And the Greens were all over it as well. Advocacy is important. We'll ensure that advocacy doesn't prevent groups from maintaining their charitable status. But since Greenpeace has now been successful, they've suddenly lost interest. Are you surprised? This decision reveals just how far the state is overreaching their control and power to attempt to shut down free speech and certain points of view that it doesn't like. Now, we've produced a record of what happened so that you can fully understand what has occurred, and it includes a timeline going right back to March 2010 when it all sort of began. Yep, we've fought this through 4 cases, 2015, 2018, 2020 and 2022. It's cost hundreds of thousands of dollars for both us and for the taxpayer. And our case has been a significant one because it will concern all charities which have a point of view, and it affects freedom of expression and open debate. I've always said to opponents who probably celebrated our demise, what if the tables are turned and the government decides that your views are not in public benefit? Shouldn't we be brave and strong enough with our own arguments to allow opposing views? It appears that certain views of marriage and family are now deemed out of bounds by the state. Now, the report also has a wonderful commentary from our board member, Bruce Logan, who argues that the Supreme Court's decision demonstrates its submission to the religion of diversity, inclusion and equity, now deeply embedded in New Zealand culture and law. Bruce says that the Supreme Court has already given up on balance and neutrality by presuming cultural relativism, the overarching reality. And there's also a commentary from charities law expert Sue Barker, who hopes that the court decision will wake up charities and that the New Zealand legislation provides insufficient guidance as to how to determine whether a purpose is charitable, which means that we're going to spend hundreds of thousands of dollars arguing over these issues. And she argues that the whole issue has become problematic and complex. And she says this, just finally, the Supreme Court decision in Family First has the potential to be used arbitrarily as a weapon against any charity that happens to express a view any given decision maker doesn't agree with. So the current government doesn't agree with. If Family First can be deregistered for engaging in the democratic process, any charity can. The misery of left-leaning charities in places such as Russia and Hong Kong provides a glimpse of the potential future for LGBTQ plus charities in New Zealand if the test for charitable status is permitted to turn on the subjective whims of officials. All it will take is a different decision maker, and it won't be long before they are coming after you. Correct. That's a warning to left-leaning charities who perhaps celebrated our demise. Look, if Family First is deemed to be non-charitable because of its advocacy and activity, the real question is whether the government will pursue other charities who operate in a similar fashion and do political advocacy, and who Family First have possibly engaged with during social debates, such as cannabis legalisation, but from the left-wing side of political discourse. I mean, is the Supreme Court now going to target the Helen Clark Foundation, Drug Foundation, Child Poverty Action Group, Amnesty International? Well, you probably know the answer to that. And that actually reveals the real agenda. But an activist judicial system is just another weapon in this agenda.